Make sure all the tubes are connecting out there on the interwebs. I see some people chatting away over there. Zulu's in the house. Ronnie Cole's in the house. We've got Ralph T, Mark Green, Joseph Plasmeyer are all saying hello. We got Radices over on Locals chiming in. Good to see you, Radice. Let's see. And it looks like we're working. Things are alive and well. My goodness. So let me make sure that you can hear me. Everybody, let me know if there's any problems, but we're going to get started. Happy Sunday, everybody. Welcome to yet another episode of Watching the Watchers Live. My name is Robert Govea. We're going to dig into some Sussmann juror role play today. And it's not what you're thinking. This is a family show. This is a PG, maybe 13 environment. We try to keep it, level-headed here, but we are going to talk about role play today because we actually have a copy of the juror questionnaire. We're going to take a look at what this looks like. There it is, and it is 32 pages, but we're going to go through it in a little detail because there are some good questions and we can see sort of exactly what the jurors are seeing. Remember, it's Sunday night. Jury selection starts tomorrow with questions, and we've got the mind map that helps us get our bearing straight. Remember that we're in Judge Cooper's courtroom, and we've got a trial order that he posted previously. And so we can see we are just coming to the very end of the line on this. We have the whole schedule here. We have the administration of the jury questionnaire. Jury selection starts tomorrow. We've got everything unfolding rapidly, and the trial is going to be very interesting. So we're going to go through that. We're going to go through the questionnaire. We're going to take a look at the court docket. You can see I just did a refresh on this, and there was not a lot of activity from sort of the prior week, or actually since the last time we covered it. If we zoom in on this, you'll see we've talked about most of this stuff. A couple interesting things did pop out, and we may spend some time on this, but I wanted to show you this. Eric Lichtblau. Now, this guy is a New York Times or former New York Times journalist. And if you take a look at what happened last week, we had on May 12th, very interesting thing happened. Two different lawyers entered their appearance on behalf of this guy, on behalf of Eric Lichtblau. And if we take a look at him and we do a quick search on this, let's pull him up. We can see that he is somebody who was I believe, New York Times journalist. Yeah, this is what he looks like. So he got a lawyer, and they filed 2 notices of appearance, and they are now going to be sort of trying to defend themselves in this case because they don't like where this case is going, saying that they want to, sort of invoke some of their privileges against testifying in case Durham calls him or the defense calls him. He's going to say, hey, I'm going to start invoking my rights. And he was one of the journalists who was communicating with Fusion GPS they were sending emails back and forth, or allegedly that was the story there. So we've got a lot to get to, and we're going to break this down sort of bit by bit. Remember that it's Sunday night. Jurors are at home. They're getting ready for their week. They remember, oh, darn it, I have jury duty tomorrow. I guess I better open up my mail. And if you're like me, I just sort of hate mail, and I just sort of have stacks of it that just kind of, piles up, and then I fly through it and I just shred most of it. But you're one of those jurors and you take a look at this one and you say, oh my goodness, we've got here jury selection questionnaire. It's 32 pages. It's a big whopping document, and they're going to have to start going through it. So let's take a look at what they get once this lands in their inbox. Looks like this. Jury questionnaire, 32 pages. It says, prospective juror, you have been selected as a potential juror in the case of United States of America, which is John Durham, against Michael Sussmann. And as part of the jury selection process, you've got to complete this questionnaire today. Return it next week when you show up on May 16th. Now, they tell us, and I've been sort of wondering how long this trial is actually going to go, but they're telling us it's going to last 2 weeks, although it could go longer. And this is largely because it's not a lot of witnesses. Remember, when we go back over to the mind map and we X out of the trial order, we zoom back out. Remember, this is a complicated case because there's so many different parties involved. But when we look at the mind map, we got to remember that it's really one defendant, it's one prosecution, it's one criminal charge. That's it. There's only one charge, and it's only against Michael Sussmann. All of these other people are ancillary to this criminal case. They're all relevant to it, and I think very important to the entire narrative. But it's one lie. It's one meeting with the FBI. It's just a couple of witnesses who are there really to hear some of the evidence. People who were at the FBI, we talked about them a lot. James Baker, general counsel at the time, Tricia Anderson, general counsel, deputy general counsel under James Baker, and then Bill Priestep, who is the deputy director. They all had their notes. We've taken a look at their notes. They look like this. And if you zoom in on that, it says Michael Sussmann said he's not doing this for any client. So just to get up to speed, this is all, everybody's involved in this, but it's really not that much. And if you compare and contrast this with, let's say, I don't know, what do we talk? We've covered many other trials here, but Ghislaine Maxwell, for example, right? She had 4 different victims, decades of evidence, 4 different locations, hundreds of exhibits, or thousands if you add them all up. We take a look at Derek Chauvin. We had weeks of medical testimony. We had people coming in and talking all about, whether there was enough force on George Floyd's neck, whether it would actually asphyxiate him or not, right? We were debating all the medical science, and we had the lung expert come in and talk very clearly about the different science behind breathing. Here, it's just a lie, and it's just a handful of witnesses. And so we'll see how long this thing actually lasts, whether it is 2 weeks or not. But the court tells the jurors, those selected as members will in fact live at home, so they're not going to be sequestered. You're going to have the weekends free to yourselves. Your contact with people will not be restricted, although beginning now and continuing until then, you're not permitted to talk to anybody. And they give us a little background about what's going on here. In this case, they say, the government has accused the defendant, Sussmann, of making a false statement to the FBI, to an FBI official, and has charged the defendant with 1 count of false statement. A more detailed description will be given to you later. They tell us now, and they have to give us some background because the jurors, remember, if the jurors, know him, if the jurors say, Michael Sussmann, he's my neighbor, or Michael Sussmann, he's my brother-in-law, weird. Well, then they've got to let the court know about it so that they can get booted off. He's 57 years old, U.S. citizen. He has pled not guilty to the charge, and he's presumed to be innocent. The purpose of the jury selection is to select jurors who have no bias, can keep an open mind, can follow the judge's instructions. Our goal is to select a jury that will reach a verdict only on the basis of the evidence in front of them. So the information you give us is very important. The purpose of these is not to ask about personal matters, but we just need to determine if you're biased or not. And remember, this was the same thing that juror number 50 flew through when he was just wanted to be on that jury so bad for the Ghislaine Maxwell trial. He answered he was juror number 50. I forget, it was question 28 or 29. They said, have you been the victim of something like this that has happened previously? And he said, no, I hadn't. Turns out he had. And of course, that means he might be not an unbiased juror. We continue. It says, to protect your identity, only this page will be captured. Please answer the questions. Please print your names, use ink. Please answer the questions without the help of anybody else. Do not discuss this case. Do not let anyone, friends, family, or personnel, or anybody else talk about this case at all. Do not read anything whatsoever about this case or watch YouTube channels that are talking about this. So if you're, if you're a DC juror out there and you're like, this is great. I got mine in the mail. Maybe we can just do this together right now on YouTube. Don't do that. Turn this off. Go fill out your form without listening to this. And do not post anything about this on the internet or the blog. Don't listen to any news. Don't listen to any radio. And don't get on YouTube. Do not communicate about this with any other potentials on jury. There it is, specifically YouTube. Oh, those. Well, now we know. Get off the YouTube is what they're telling us. Finally, you're expected to sign your questionnaire. This is going to be under oath. You are sworn to give true and complete answers. Go ahead and do it. The Honorable Christopher Cooper, United States District Judge. So then we get the big question. Now we'll go through this, and some of it is going to be, what you'd expect out of a form, but there are little questions that we can tease out some interesting things. They say here, complete this preliminary matters first and foremost. 2 weeks, could go longer. Let's make sure that we get out of the way any procedural problems that you may have. If there is a trial, it might take place on Fridays. If there's any reason why you can't be here, you got to let us know. Like, are you, due up for deployment, or are you leaving the country for something? If this takes 2 weeks, can you be here for 2 weeks? English, do you speak it? Have another one. Do you have any moral, religious, or ethical beliefs that prevent you from being on the jury? Any physical, medical conditions? Are you somebody who can't sit or focus for long periods of time for whatever reason? Are you somebody who is about to undergo a serious health surgery that might make you incapacitated for a certain period of time? How about sight, sound? Do you have any hearing difficulties? Are you going to be paid by your employer? If not, is that going to cause a hardship? These are all preliminary questions, and so we can fly through most of these, but we've also got some background information. Now, if you've never sat on a jury, and to be honest, I've never sat on a jury. I got a jury questionnaire one time. I think I was in law school, and I sent it back. I said, no, I'm in law school. And they said, all right, well, you're probably not going to be a good juror. And I've never been called back. So I've never actually had to sit on a jury other than, sort of in law school. I did a trial practice class where actually I didn't even sit on a jury for that. I was doing the trial practice. So I've never really sat on a jury. I've sat in the audience of a trial in the courtroom many times, but not actually had to make a decision as a juror. And I'm certainly sure that I will never be allowed to do that now just because of my opinions on the courts. But here we can see they're going to ask some of those basic questions. If you have in fact sat on a jury, maybe you asked or have seen some of these questions previously. We go about employment, full-time homemaker. Are you a student, retired, disabled, any of these things? Also, if you are a student, full or part-time, please describe your area of study, talk about your employment, any other jobs you've held, describe your spouse's occupation, their primary responsibilities, and their length of employment. And they're trying to, if the judge is listening to somebody and they're saying, well, it's impossible for me to take off work, they're going to say, well, you married? Okay, well, can your wife cover you for 2 weeks? Or, the judges are really kind of difficult about this. They don't want people to squirrel out of this, which is why you can see they're asking so many of these questions. Are you, your spouse, anybody else, a contractor, subcontractor for the United States government? Are you going to be biased? If you're getting paid by the U.S. government, are you just going to find in favor of the U.S. government? Maybe you might be biased. The defense may want to know that. Oh, you've got a nice little subcontract from the feds. Wonder what that's for. Maybe you shouldn't be a juror. So we have here, check the highest level of education you attained. They want to know all of this. I asked the question, would you get on the Sussmann jury? So you can sort of play along as we go through this. But, some of these, of course, are not naturally disqualifying, but some of them, if you're an attorney, some of these things you are curious about, absolutely curious about. Here, let's say, for example, in a DUI case, right? If you're in a DUI case and you get a jury panel filled with a bunch of postgraduate study students or graduate degree students or PhDs, right? People who think that they're very, or maybe they are very sophisticated with, science and technology and all of these things. Maybe you can present a numbers-based argument in a way, whereas other jurors would just sort of gloss over, right? If somebody starts talking about numbers to me, I'm just like, what? What are you talking about, right? I'm sort of a visual person. What are the nuts and bolts? What are the mechanics of it? I'd rather look at a flow chart than a spreadsheet. And, some people just learn differently and they're persuaded differently. So if, as a lawyer, you start to see a big batch full of different educations, right? Or technical or business schools or 4-year college degrees, or you don't see any college degrees, or, you can see a permutation of how this might vary and how people may respond to different arguments. It continues, right? Major areas of study. If you start to see doctors and nurses and you are a DUI lawyer, you start to get a little bit nervous about that. Why? Because doctors and nurses, well, they often see some of the damage of what happens in DUI cases. Same types of things with, school teachers, right? Or something, an industry that is around a lot of children. Maybe you don't want to bring them on a jury that has some, allegations involving those types of crimes. And so you're thinking about all these things in real time. And so this feels extremely invasive. You need to know about my spouse. You need to know about my wife and my education and all this stuff. How about you just ask me whether or not I can make a fair rendering of a verdict as this trial goes on? But they want to sort of peel back all the layers of the onion and really get a full internal view of who you are. Any education, college, major areas, degrees, or certificates, flagging all of those. And typically what you'll see when juries are being compiled is defense attorneys and prosecutors will often, create different charts. In other words, where they'll list the jurors in the rows, they'll list the variables that they're concerned about on the columns. And so they'll say, okay, juror number 1 is, this variable and this variable, but not this variable. Juror number 1 is a doctor, somebody who has, post-education, and somebody who has this, but they check different boxes. And then very quickly, you can kind of get an overview on what you're looking at. And some attorneys do it differently. There's now software and people use it on iPads where they just plug all this stuff in and they can create literal profiles of the jurors almost in real time. And then if you go to these CLEs, which are continuing legal education, where they teach you how to pick juries, they'll start to, hone in and they'll say, well, maybe you should ask the jurors what kind of news they watch and what kind of magazines they read and what kind of YouTube channels they listen to. And you can start to profile jurors based on some of those attributes. And you might say, historically, maybe a Fox News viewer is somebody who's a little bit more conservative. And so maybe they're a little bit more aggressive in terms of punishing a defendant. And maybe they are not somebody you want on a jury. That's something that I've heard from a lot of defense attorneys out there. Conversely, you can make the same argument. You could say, well, maybe the Fox News viewer is somebody who is, questioning the government. Maybe they don't like to buy the standard narrative that is shoved down their gullets from other traditional media. And maybe they would have a little bit more of an open mind and question what law enforcement is doing. And so you can see how you can split this both ways. There are other lawyers out there who will literally not ask any questions. They just pick the jury. I don't care what it is, right? Because they think that all of this splicing and dicing is just a little bit too granular in a way that doesn't produce results. And so you can see, just like anything, this is why they call it the practice of law. And it can require, it's almost like an art form, many people would say. Here we go on. Check whether you or your spouse is involved in any one of these categories: law, paralegal, the legal field, criminal justice, law enforcement, you or your spouse, right? So if you're sitting there, if you're listening to this in the audience, you may ask yourself if you check any of these boxes. Criminal justice, law enforcement, they may not want you on there. The defense may not want you on there, certainly, because they're going to say, oh, this is a law and order type. This person is clearly going to convict the defendant. Security and intelligence, maybe this person would listen to the arguments. Okay, in this trial, we're talking all about DNS records. Remember, we have Rodney Jaffe, we have these two characters, Glenn Simpson, Peter Fritsch over from Fusion GPS. They were the co-founders there. We have Laura Sego, who's going to testify. Jake Berkowitz was over at Fusion GPS. All of these people are going to be allowed or be talking about technical things. The Judge Cooper has ruled that we can't go too in depth over these things, but has said that, yeah, you can sort of explain this. In other words, the jury can hear what Michael Sussmann, sort of what the context was in which he was operating. Sussmann doesn't get to just show up to the FBI with some paperwork and just say, oh, I just dropped this paperwork, these 3 white papers on your desk without any explanation about what was going on in his mind. We can layer that on, but we can't go too in depth because the judge doesn't want this to spin off into something that is irrelevant. But that being said, right, if the jury questionnaire identifies a bunch of people that are involved in security intelligence, or let's say, we just start checking off of some of these things. We have a DNS person who's here, or a spouse, IT people, cybersecurity people. These are huge industries now, right? These are, basically the backbone or sort of major threads of the entire economy. There's millions of people who work in these industries. And so if they are part of the jury pool, maybe you want to identify them, because they'll take that DNS argument, they'll take it to the other jurors and they'll say, yeah, it's ridiculous. Rodney Jaffe was making the claim with those researchers that they could create an inference about Donald Trump and collusion with Russia. And researcher number 1, who's probably going to testify in this trial, came out and said, I think we're sort of chasing our tails here. We can't come up with enough to create this narrative that you want us to create. Maybe we just are blinded by our Trump hatred, which of course is true. But those arguments, if you're talking about DNS and all this complex stuff going over people's heads, that's not really what you want to do in a jury trial. Let's take this back to the DUI example. In a DUI case, there's all sorts of, very sciencey things that you can talk about, partition ratios and how you have a vial and there's headspace in there and you puncture the headspace and it pulls the air out and there's really no, a blood that's actually being drawn up into the gas chromatography machine. You can spend a lot of time dissecting it all. But most people on a jury are just going to go, what the heck are you talking about? It's ridiculous. I don't get it. And then they're just going to default, is what defense attorneys fear, is to just a conviction, because you're going to say that defense attorney is confusing the heck out of me. I don't know what they're saying. And when you go to these trial colleges, they're telling you, look, you got to communicate very simply because you don't know what the panel's, sort of collective intelligence is, whether this is totally insulting people, whether this is irritating people, whether some people are totally getting it. It can be very confusing. And so they say as a general rule, you sort of want to default down. And when you look at the numbers, lawyers can be more successful with more persuasive arguments versus the lawyers who go in there and they just slice and dice with numbers and statistics and graphs and different flow charts, right? It's about communication. It's about persuasion. So here, the lawyers are looking at this data, and I don't know that much of this is necessarily relevant to whether somebody can be fair or not on a trial or on a jury panel, but it's certainly good to know. Both sides are very interested in this. Why? We're also going to see that some of the people in this trial fit these categories, right? Mark Elias is somebody who works in law. We have university professor, somebody who might actually be a witness here. We know that researchers are certainly going to be a professor, or are going to be involved in this. Many of the researchers were coming over from Georgia Tech. Politics, lobbyist, fusion GPS, right? These are also illustrating the categories of the people who are going to be talked about in the trial. And why is that important? People might identify with them. If you're a lawyer and let's say I'm a defense lawyer and I'm on the panel and I see another defense lawyer who's on trial for a crime, well, maybe I say, well, defense lawyers get a bad deal. Maybe if you're a teacher and you're watching a teacher get charged with a crime, maybe if you're somebody in construction and you're watching a fellow construction person getting charged with a crime, you're saying, hey, maybe identify with that person a little bit more. And here in this case, maybe you've got lawyers siding with Sussmann, or you've got university professors and researchers siding with Rodney Jaffe, or different people siding with Mark Elias, who was Hillary Clinton's chief campaign lawyer. We're trying to identify this. We move on to the next page because there is a lot here. But are you currently, if you're a prospective juror, have you ever been a member of any social, union, professional, business, fraternal, recreational, or community groups or charitable organizations? If yes, what's the name of those groups? Remember in the Derek Chauvin trial, we had another juror, I forget what his name was, Brandon Mitchell, if I'm remembering that right. And remember, he was a part of a couple different organizations, and he went to a couple different community groups, if you recall. Remember, he had the shirt, actually, before he was selected to be on the Derek Chauvin jury, the shirt where he was on podcast saying, "Get your knees off our necks." And then when he was filling out this form, what did he say for this question? Are you currently a part of any community groups? And he said, nope, not a part of any of them. Even though he was part of a clear community group, they were all wearing the same t-shirt and they were showing up on podcasts together, championing a cause, which is perfectly fine. I don't have any problem with that. I like political and civic engagement. We do a lot of it here. But here we see that you got to disclose it. You got to write, yes, I am a part of the group. What is it? I am part of, I don't know, whatever it is, BLM or whatever. You'd have to write that down. And they also want to know, what are your hobbies, your recreational, leisure, and spare time activities? So, depending on what those are, you put those down. It could be very, very, I like to take walks in the park or whatever. Or it could be a little bit more, disqualifying. I don't know. How often do you seek out positions of leadership at work or in other groups? Which is perfect. So let me ask you this, sir. Are you kind of a loser or no? Like, are you ambitious at all? Are you trying to lead things, or is the answer never? You just don't want to participate. You just kind of, whatever, I don't care. And let's see here. Yeah. So I just saw some super chats come in. So thank you for those. Ronnie Cole says, good thing the trial is in DC. Otherwise I would be worried. Kate Hale with another one with the super chat. No question. Thank you for that, Katie Hale. I appreciate that. Pull that one back up on the screen. And then Death asks a question. Can you refuse to answer these questions? They seem invasive. Yeah, they are pretty invasive, right? Any position of leadership at work. What if you say no? What if you say yes? Now, what are you identifying? You're identifying those strong-armed jurors, those jurors who are going to go out there and just start throwing their elbows around, who are saying, oh, no. He's guilty, or no, he's not guilty and I'm not doing anything otherwise. Do you ever take leadership? They want to know, are there 35 people on this panel, all of you saying, yes, we all always take leadership? So we're going to have a bunch of alpha, Chad bros out there elbowing each other's heads into the table because they want the right verdict, or not. Have you or any member of your family ever attended a meeting, sponsored an event, or any group that deals with reform of the laws? Are you politically active? They're wanting to identify, I probably see where this is going. Here it is. Yeah, actively involved in politics, fundraising, voter registration, candidates for office, candidate staff. Why would that question be important? Well, it's because it involves the entire DNC. If we zoom out on this, look where this all starts. Let's close up some of these branches. Oh, yeah, there it looks. Who? Oh, it's Hillary. It's Hillary. There she is. Why? Because Hillary Clinton, Hillary for America, same law firm, or hired the law firm Perkins Coie. We zoomed that out. They hired Fusion GPS. Fusion GPS was the consultancy that worked with Rodney Jaffe. All of this was being funneled up into Perkins Coie. Who else worked there? Well, it was Mark Elias, who was Clinton's general counsel at the law firm. Same guy who founded Democracy Docket, same guy responsible for a lot of the success of the DNC against Donald Trump in the 2020 election. He was basically leading the entire counter assault to Trump's litigation back in 2020. So this involves a ton of Democrats. The FBI knew that Perkins Coie had represented a ton of people from the DNC, also from I think the DOJ also, right? A very big law firm, a lot of people there. So they're asking, are you a Democrat? Are you a Republican? What are your politics? Because this is going to be a political case, and we need to know if you're going to be biased or swayed because of this one way or the other, or can you set that aside? So if somebody comes out here and says, yeah, I'm a Republican and I phone bank every weekend for the GOP. Well, they're going to say, all right, we got to ask that juror about those questions. Do you or your spouse or anybody contribute money to any think tank, public policy, or advocacy group? Ooh. If you did, we need to know more because maybe you've got a bias. If so, describe the causes without revealing which candidate you voted for. Did you vote in 2016 presidential election? And so Des says, yeah, can you refuse to answer these questions? I mean, you could refuse to answer them and just say, I refuse to answer them or not answer it. And they're going to ask you about it, right? They're just going to go through each one of these and say, you didn't answer 32. Why not? And they're going to ask you and you can say, well, I just choose not to answer that. And then the judge and the defense and the prosecutors can all ask you about what to do with that. But it's a good question. If you don't feel comfortable, I don't feel comfortable about sharing that. They'll say, well, maybe this person is, not open enough that we can vet them in a manner that would allow us to consider them to be fair and impartial. Without revealing which candidate you voted for, did you vote in the 2016 election? That's Trump versus Hillary. Now we get to ask, who'd you vote for, essentially? That's pretty important, isn't it? What happens if you get a bunch of Hillary Clinton voters on this panel? And it's DC. So you probably are, unfortunately, right? You're going to get a bunch of Democrats on there, no matter which way you throw the dart in DC. You're going to hit a bunch of them. Peacefully. It says, item 33, did you work for or volunteer or contribute to any of the 2016 presidential campaigns? What if you say yes? Yeah, you donated a ton of money to Trump and you get a bunch of Trump voters on there. Yeah, the limit, all of it over to Trump. You're going to get the defense. Sussmann's defense team is going to be screaming from the rooftops. This person is biased, throw them off the panel. And conversely, the same is true. If the prosecution sees a bunch of Hillary donors, they're going to try to, see that and boot them on out of there. We have 34 says, are you presently a member or do you attend a church, a synagogue, a mosque, a temple, or any other religious organization? Why? Because you can correlate different religions with different political affiliations. Generally speaking, broad strokes. And that's what this whole thing is. It's just a big demographics sort of analysis to see who we can put on there and how they might affect your case. Have you ever served on a jury? Do you have experience? Yes or no? How many times? If yes, what kind of cases have you been on? Have you ever been the foreperson? Have you ever led a jury before? Are you going to be the person who is throwing those elbows? Have you ever served as a juror on a grand jury in federal or state court, which is a different proceeding? Those are closed door proceedings that happen when they're making charging decisions. Typically, the defendant or the representatives are not there at the time. Sometimes if you get wind that they're happening, you can, in Arizona, be there, but it's a different proceeding. So they're separating that out. But if you have, let us know about that. Military service, they want to know. Ever served in the armed forces, branch, highest ranks, type of discharge, date of discharge, describe your duties. Same thing happening here, right? Military service members as a general category may fall into different political affiliations, different opinions on criminal justice matters, different opinions on how people should comport themselves, and have a different perspective on all of this. And so they want to know, is this somebody who just, joined the military? Do they come from a long family lineage of service members? How does this person fit in? Media exposure. Now, this one might be interesting because they live in DC. You and I have been paying a lot of attention to this trial and covering this in depth for months now, but many other people around the country just have not. And we'll see how much attention it gets next week. We know that there's a lot of other stuff going on, and this has largely been, I think, thrown to the side, but maybe there'll be some attention. We'll see. But it tells us, jurors, have you seen or heard about this? And I want to just pause on this for a minute, right? The year is 2022. This all happened in 2016, right? The meeting that took place between Sussmann and the FBI was September of 2016. We're almost 8 years later. And this is now just seeing trial. So maybe they did see and hear about this, I don't know, 5 years ago, 6 years ago. Maybe they've heard about it recently. But that's the gears of justice, right? First of all, we've had Trump's entire presidency take place, and then we had another presidential election. So you start to ask yourselves, what repercussions were there really to any of these people who were involved in any of this? Well, we'll see. I mean, Michael Sussmann, we'll see if he gets convicted, if there's any repercussion for it. But my point is, once the damage is caused and you start to identify the malicious actors, it's already over. The game's over. And so if you can concoct a scheme like this, you can win the game and delay punishment for, 6 years after the fact and just let it continue on. And it may terminate without any additional penalties befalling the actual perpetrators. So if they did something, hypothetically, if they did something in 2020 and they also win power and they have the levers of power to stop, the unwinding like we have seen happen here with a special counsel being prosecuted through John Durham, by Donald Trump actually taking the reins for a little bit, being able to crack this open. What if Hillary would have won? Maybe this whole thing, maybe there was no special prosecutor. There was nothing that happens that leads to an investigation here, even with a current special prosecutor and a full-fledged investigation that's been taking years. It's still 6 years later. So, good question. Have you heard about this? I mean, maybe you did a long time ago. Where do you get your media? I talked about Fox News and some, MSNBC and the different generalizations that attorneys make based upon these questions. But where do you get your news? Television, radio, internet, social media, other sources, YouTube. Subscribe on YouTube if you haven't already. Thanks. Love you all. Do you follow local or national news? Do not follow is what they say. Maybe you don't. Maybe you've never heard of this at all. Maybe you're just like, I have no idea who these people are. And if you do pay attention, well, what channels are you listening to, right? Newspapers? Are you listening to Rachel Maddow? Are you listening to Tucker Carlson? Do you watch opinion media? Do you listen to talk radio, programs on cable news, podcasts? If you're a juror, you're sitting there in DC filling this thing out. You're saying, yeah, I actually do listen to that one and that one and that one and that one. And I subscribe here and I subscribe here. Do you have accounts on any profiles like Facebook, Twitter, Instagram, LinkedIn, Snapchat, or others? And how often do you use these things? Daily, several times a week, rarely or never. They also want to know what your favorite TV shows are. It's like after jury selection, they should really see if you are romantically connected with any other jurors, right? Kind of turn it into a post-jury duty dating bonanza. because you've now bonded through a traumatic experience together. And now they know, and they can say, hey, oh, your TV shows match her TV shows or his, or however this whole thing works. And they can just pair everybody together. It's beautiful. And if you don't like that juror, you just swipe left or right or whatever you swipe. Hey, maybe that'll be a startup one day. What are your favorite TV shows? So you post those down. Do you regularly watch TV shows about, now this may get a lot of people here. Do you regularly watch shows or documentaries about law enforcement, criminal investigations, trials, espionage, or foreign affairs? If you watched the new Jack Reacher, which was really good, I actually liked that one a lot. Disqualified. Do you think you're a spy? Do you think you're a police officer? Do you think you're a secret agent because you watched Jack Reacher? Oh, you're a forensic scientist because you watched CSI? Oh, okay. That's what they're saying. That's what they're basically implying. That's the question, right? It's a little condescending, but that's what they're asking. That's why I put it condescendingly. They're saying, do you think that you're super smart and that you're going to be able to get on there and like talk to the other jurors and say, well, I watched on TV one time. They're asking that right there. Do you think, and if yes, what have you watched? Like, have you watched Staircase? Have you watched, what's the other one? Making a Murderer. What happens if you watch Making a Murderer on this one, right? You say, okay, Making a Murderer. Maybe you say that every single prosecutor or law enforcement officers are liars and cheaters because you saw that and you realize that you can't trust anybody. And maybe you don't know, the whole thing could be set up. And maybe you have a lot of disdain for law enforcement and you take a look at the FBI and you say, those people are goofballs who are just playing Where's Waldo all the time, trying to find the J6ers. They couldn't even tell what that thing was. They thought it was a sort of a model recreation for the insurrection that almost took down America. But that's what they want to know. They want to know if you think that you're smart. Here it goes. Have you ever followed media coverage of any trials, right? Same type of question here. Same type of thing. Oh, right. They want to know. They want to know what base level, layer they're at. Now, most of these questions, are not on, sort of typical jury selection. This is a huge trial. And this was jointly prepared by both sides. So I sort of forgot to mention that at the beginning of this thing. Here you can see that these were actually jointly proposed, right? So this is not like sort of a standard form. There are standard forms and jury questions that they'll come up with, but and they're typically called Raji here in Arizona. We have standard jury instructions. It's Arizona jury instructions, but it's here. These are jointly proposed. So let me show you what I'm talking about. I forgot to cover this at the beginning, but here we have, okay, so back on May 9th, these were jointly proposed by Sussmann and Sean Berkowitz. Okay, so back on May 9th, they proposed these. So what happens is both sides come together. We see joint instructions and joint verdict forms, and then the judge reviews them, and then the judge says, okay, you know what, I'm going to sign off on those. Those all look good to me. And so that happened about 5 days apart, May 9th, and then May 13th is when, so I think it was May 9th, 12th. I forget how many days apart it was, but very quickly, they sent over the joint forms. They turn it back over. Judge says this looks good. And then they turn it out. And so we go back over here. Now we dive into the knowledge section. Also, 48, before we jump into the next section, says, to assure that the decision of a jury in this case is not based on influences outside of the courtroom, you got to avoid reading all of this. You can't discuss any of this. Will you be able to follow these instructions? You cannot communicate about this with your fellow jurors. Yes or no? Can you follow those instructions? Yes, you can. Okay, move on. Knowledge now. Let's go back through this one. In this case, the charge arises out of a meeting that took place between Sussmann and former FBI General Counsel James Baker in September of 2006. So we are just now, in 2022, getting to a trial date. And if Hillary would have won, maybe this whole thing never would have come to fruition. But we now fast forward, we're 6 years down the line. James Baker is this fellow who is down here. He was part of the FBI. He was general counsel at the time. And he is now, I believe, over at Twitter, which is just perfect. And so remember that Sussmann went and had a meeting with James Baker. Now, this is the text message, I believe. Yep, that Baker sent. Oh, that's so small. Let's see if I can zoom in on this. Here it is. This is the text message that Michael Sussmann, this guy, let me read this first and then I'll zoom back out. Michael Sussmann sent over to Jim. Jim, I have something time sensitive and I need to discuss it. Do you have availability for a short meeting tomorrow? I'm coming on my own, not on behalf of a client or company. I want to help the Bureau. Thanks. So that's the message that Sussmann sent over to James Baker. I'm not coming on behalf of a client. They're giving us some of that background here. Now, the jurors don't know that text message, right? They have not seen it, but we, of course, have. They say, there is nothing wrong with having heard or read about this case, but it is important that you truthfully and fully answer the questions. The judge in this case is Judge Christopher R. Casey Cooper. Do you know him? Remember this judge. And he's an interesting guy. We've been talking about him. And he kind of gets a little bit jovial with the defendants and with the prosecutors. And he says, oh, it's good to see you in my courtroom. You know, you haven't come down here from New York in quite some time. Nice to see you in here there, Mr. Berkowitz, Mr. Bosworth. And I know judges like that. So he'll be fun. I think he'll be kind of fun to listen to. Or read, since we're going to be reading the transcripts. But he is, of course, somebody, if the jurors know him, you got to let us know. Yeah, I play golf with him. Yes, he's on my soccer club. Same thing. In this case, the government going to be represented by special counsel John Durham. Dun, dun, dun. And also the following assistant special counsels. Do you or have you had any social or professional contact with any of these people? And we really couldn't find too many of photographs from these people. Although I did find Britain Shaw. So I found her. Here is her. So we've got Britain Shaw. I got to get the other prosecutors in here. So Andrew DeFilippis is somebody who's got to be added in there. Andrew DeFilippis. And there will be others. So we'll populate that sort of as that goes on. Michael Keelty and Jonathan Algor. So we'll do an MK and a JA over here. Fill out these prosecutors. Now, as this trial goes on, we'll try to beef this out. And I'll try not to spend too much time on it. But if the jurors are familiar with these people, they got to say yes, just in case we can disqualify them. Same thing, we've got the defense now. Sean Berkowitz, Michael Bosworth. I found photos for those two people. They are going to be over here on the defense, and they're representing Sussmann, so they're here. This is Bosworth. This is Berkowitz. I might have those names wrong. I actually think I might have those wrong. Apologies. We'll get those correct. I think this is Sean Berkowitz. And I believe that this is Michael Bosworth. But we're going to be exploring this thing in real time as this case unfolds. But those are the two people representing Sussmann. And they've got a number of other defense lawyers all coming out of New York, Natalie Rao and Catherine Yao. If you know them, let us know so that we can detail whether that's going to make you biased. We also have Michael Sussmann. He's 57. He's a resident of D.C. Do you or anybody you know Michael Sussmann? If the answer is yes, tell us. How about this? A lot of different organizations. You see why those political questions were so important, why those political documentaries were so important, why those espionage firms were so important, why the shows that you watch were so important, because they're going to be talking about all these things. And they want to know where you stand on them. First, we have Alpha Bank. Talked about them, and that's the bank that they were trying to show or create that inference that there was communication between Trump, that Alpha Bank was being sort of used by Paul Manafort and others to funnel money back and forth from the Kremlin, all a bunch of nonsense. FBI, forensic shows, James Baker, right? FBI General Counsel. Donald Trump, Trump Organization. Do you know these people? Are you involved in them? Have you supported them? Did you donate $1, $25? Did you buy a MAGA hat? Hillary Clinton, right? Did you buy a Hillary bumper sticker or whatever she was selling? Hillary for America, Rodney Jaffe. He was a senior technical expert, Perkins Coie law firm. The CIA was involved. Now, they're not at issue in this trial. They may come up. After Sussmann met with the FBI, he did the same thing. He went over with the CIA. We don't have much here on the CIA meeting. It looks like I put a note here. Yeah, the Washington Examiner. Yeah, so this was a fun story. This came out from the Washington Examiner. I linked to this. But the CIA has known that the Trump-Russia collusion data was not technically plausible since 2017, says Durham. So the CIA stuff may come out because one of the stories came out in some of the pretrial discovery that was flying around. All right, so we've got Fusion GPS, Packet Forensics, Zetalytics, Georgia Tech University. Anybody, if you're involved, if you know anything about this, let us know. Similarly, have you read or heard anything about these individuals? If you did, let us know. A list is attached at the end of this questionnaire about the names of the people who may either be a witness to this case. Please review the list and let us know. Prior to filling out this questionnaire, have you heard anything about it? If you did, let us know. Anything about Sussmann? Do you have any opinion? Have you expressed or formed any thoughts about Michael Sussmann in any way? If yes, what are they? Do you still hold those opinions today? Oh my goodness. Have you or a family member or any friends ever been employed by any of these House organizations? The House Permanent Select Committee on Intelligence, the House Judiciary Committee, the House Committee on Oversight and Government Reform. So if yes, you got to tell them. And we get some good questions about the Russian actual involvement in 2016. All right, so look at this. This thing is still going on. Let me take a look at the chat. Let's see what's going on in the chat here for a minute while we take a quick break. Going to have a water break. Yeah, K. Bean says some of these questions are redundant. I'm noticing that. Taking a quick water break here. Cheers, everybody. Some of these questions are redundant. This application is an invasive species. That is from playing hookies in the house. Zulu's here. Just Cause is in the house. All right. And so let's go back then to the questions, I think. And here we get into the Russian interference in 2016. Have you or a family member or a close friend ever participated in any media group or organization that has investigated or made inquiry into the Russian interference in 2016? Or have you been involved in Donald Trump's relationship, in the investigation into that relationship with Russia? Or the federal government investigation into Russia? So you're going to have to answer yes or no on that. I'm going to guess most of these are no, but they're trying to identify people who are, actually a part of that investigation, whether they're with, the FBI or any other law enforcement agency, trying to vet those people out. Going to guess that most of those are no's. Question 61 now. So the jurors are still sitting at home on Sunday, having to siphon through all of these things. Says, in this case, you may hear references to classified information. And we talked about this previously. There was an actual classified hearing, classified meeting that took place a couple days ago. I don't know where it was on here. We're not going to see any results of that actual meeting, but there was a meeting, a pretrial meeting, so that they could figure out what to do with some of the classified data. But they say classified information has procedures that we use in this case. Evidence is going to be admitted that will include unclassified summaries or redacted versions of classified information, but not necessarily the information itself. Do you have a strong feeling about this? So this question is asking, really, remember in the Ghislaine Maxwell case, we saw a lot of photographs that came out, and many of those photographs had the big sort of redacted boxes in them, but the jury still got to see the photographs. So they would actually look at a photograph, they'd see a massage table there, and they'd be able to put a bunch of stuff together, but there'd be a picture on the wall, and that picture would have this big blacked out, redacted image on it. So you couldn't actually see what was in the photograph. And this can be problematic in a number of ways. First of all, if you don't redact the photo, the jurors are going to see what's on there. And if it's really bad, in those cases it was bad, then they wanted to make sure they didn't see that. But there's a second problem with that if you're the defense. What happens if the jurors now are filling that in with something that's worse, or they're very angry that you're trying to hide something from them, right? You're showing them photographs that are in fact redacted and they want to see it. They're asking this question saying, do you have strong feelings about those procedures? If you see a big redacted block of blackness on a document or on a photograph, are you going to be agitated by that? Because there's going to be a lot of it, because this is a classified type of trial. Also asking about experience with law enforcement and the courts. Have you or a family member ever worked as a criminal defense attorney? Busted. So I'd have to say, yeah. And they'd say, I'd say, well, yeah, I'm a criminal defense attorney, have a law firm in Scottsdale, Arizona, on YouTube, have a show called Watching the Watchers, all that good stuff. And then they'd say, do you have any thoughts about the justice system? And I'd probably go off on a tangent, and then they'd say, you're excused. Thanks for being here. I'd say, thanks. Good to see you guys. If yes, explain. Do you have any concerns or opinions about the Perkins Coie law firm or its activities? If you say yes, do you have any feelings about large law firms in Washington, D.C.? Maybe yes or no. In general, what is your opinion of lawyers? You know, I'm not sure that that's something that I'd want to see. I'd have to be feeling very emotionally fortified, you know. But I'm sure those are good questions. If you're the judge and you get to read a lot of those, I'm sure those are a lot of fun. Also, have you or anybody else that you know been involved with any of these agencies? Same type of question we saw, the DOJ. These are huge agencies. And because these people are all in DC, there very well may be a lot of people who are connected with each one of these. Who knows? The DOJ, the Department of Justice, that's the entire U.S. Prosecutor's Office. It's a massive organization, huge. FBI, U.S. Attorney's Office, the DHS, Department of Homeland Security, Marshal, State Department, Prison, CIA, Defense, NSA, any federal, state, local prison, courthouse, prosecutor's office, or public defender's office. Basically, if you've ever worked for the government in any way, shape, or form, probably going to need to let them know about it. Several witnesses in this case may be federal law enforcement officers. The judge will instruct you that the testimony of a law enforcement officer is no greater or no less important than a standard witness. Do you have difficulty with those instructions? This is a very important question that comes up a lot basically comes up in every jury trial, but it's pretty critical as a defense that you get good answers to this question. Here's what this question's asking, essentially. If you're a juror and you have two witnesses and one witness takes the stand and that witness happens to be a law enforcement officer who gets on the stand with a full suit, a badge and a gun, with the hat on, and they look official as can be. They're wearing their body armor, and it's like they're ready to go out there and enforce justice. Then you have another witness who comes out and says the exact opposite of what that officer says. That officer said the light was red. You said the light was green. All right. So the other person comes out and they are just an everyday person like you or me. There's no, we don't have any gun or badge or body armor or, you know, official position as any member of law enforcement. And we get on there and we say, nope, it was green. Officer said red. I said it was green. Jurors, it's 50-50. It's his observation versus my observation. He doesn't have any other, you know, anything else. He didn't have any pictures or body cameras or photo, nothing. His observation versus mine. Ladies and gentlemen of the jury, do you understand that the judge says the testimony of law enforcement officers is to receive no greater or no lesser consideration just simply because of that fact? A lot of people can't get that. A lot of people will just turn around and say, well, he's an officer. He's got more training. He's got more experience. He's a better witness. He's more credible. He's more reliable. He's whatever. But they're saying you can't just do that automatically because he's a law enforcement officer. If he has more ability to explain it, you can find him more credible. You can determine that he's got a better believability, but just by nature of the fact that he's a law enforcement officer doesn't make his opinion as a witness more credible. And this is very likely a defense question, trying to make sure the jurors are sort of pre-programmed with some of this. The defense attorneys are trying to condition them to say, stop thinking as the officers as higher level witnesses. These are just regular witnesses like everybody else. Do you have any opinions or belief about FBI, the Department of Justice, the Central Intelligence Agency that would prevent you from being fair and impartial? Have you ever applied for a security clearance? Have you ever been the victim of a crime? If yes, let us know. How about a traffic ticket? This is where juror number 50 out of the Ghislaine Maxwell trial started having problems. If you answered yes, if you were the victim, do you have any opinions about the criminal justice system? Have you ever been hacked or the victim of a cyber crime? Oh, these are pretty interesting. Why might that question be relevant? Well, because the prosecutors are arguing kind of two things. Number one, that the FBI was the victim of Michael Sussmann's lie, but that Michael Sussmann was also propagating a lie that was really aimed at Donald Trump. His entire organization was essentially hacked. They even hacked the executive office of the presidency by getting access to the DNS data. Rodney Jaffe, Fusion GPS, all of them were proffering this story forward that Trump was involved in this collusion. Turns out it was all made up. So if you're a juror and you've been the victim of a crime or you've been hacked in any way, shape, or form, you might feel a way about people who do that. You might take a look at people like Sussmann and say, yeah, I remember when you people drained my bank account or you locked me out of my Facebook account or whatever it is, and be very angry. So the defense may want to identify those people. Oh, you've been the victim of that, so we're going to try to preclude you. How do you feel about the current laws that are protecting the privacy of the U.S. citizens, saying they should be strengthened and more strongly enforced, or they are fine, or they are too strong? In other words, what's your opinion on essentially the justice system? They give us some more questions about the standards. Briefly describe your general opinions about the following. Now, these questions are kind of interesting. You know, these are going to tell you a lot. These are open-ended questions. These are not yes or no's. So it's sort of like free-form questions. Tell us a story about the justice system. And so you're asking the jurors to volunteer information, not fill out a form. And you might get some very interesting questions here. What do they think about the judges, law enforcement, defense lawyers, prosecuting attorneys, law enforcement officers? I had a jury trial one time. I may have told this story before, where I was one step away from seating this jury, which would have been amazing. It was at a very small town in Arizona. And I'm a defense lawyer, as you know, so I would like jurors who sort of are lacking of trust or faith in law enforcement as a general rule. And we're about to seat this jury, and the judge asks something like, is there anything else anybody thinks I should know before we impanel this jury? And there was one woman who was going to sit on this jury, and she says, well, I think she kind of started to raise her hand up. Judge says, yes, ma'am, what do you think? And she says, well, Judge, I just think it's going to be hard for me to be on this jury since I don't trust any police anywhere ever. She said something like that. I mean, it was like just like a shocking statement. She just kind of just said it out loud. And she had gone through the whole, gone through all the questions, gone through everything. And she just didn't, you know, she had not spoken up. And like right before. And so if you're a defense attorney, you're like, oh, darn it, that would have been a great juror to have on the panel, because that juror would have been like absolutely not guilty 100% of the time. That trial actually worked out well for us. I think we split that one. But she didn't make it on the panel, and it was a bummer. I was sitting there. I was like, could you have just waited for like 10 more minutes? You would have been on there. Anyway, she got booted, and we had to replace her with somebody else. And, you know, it was just kind of a funny experience. The whole courtroom, even the judge was like, wow, okay. Well, thanks for telling us. I guess it's good that we know that now. So anything can happen at these things, especially if you leave those open-ended questions, right? In my case, the judge just said, how do you feel? You know, like anything that we haven't talked about yet that you want to share with us? And she just volunteered something, and it was an interesting question. So they have the ability to do that on page 20. The judge is going to instruct you that the defendant, Sussmann, is presumed innocent, cannot be found guilty unless there's a unanimous verdict. Burden of proof is resting with the government. Prosecutors have to meet their burden. Otherwise, this case is going to be a not guilty. This means if the United States fails to prove the defendant's guilt beyond a reasonable doubt, you must find the defendant not guilty. It's the burden of proof standard. This is a beautiful thing. Beautiful thing. Love this. Absolutely right. And if you can't adhere to that, got to go. Judge will also instruct you under the law saying a defendant is accused of a crime does not have to testify. If Sussmann doesn't testify, you're not going to hold that against him, are you? Also very important, your right to remain silent. And they can't hold that against you. The prosecutors can't come up there and say, you know, Sussman's sitting right there. He could just get up here and explain himself to you, ladies and gentlemen. If he really wasn't lying, why doesn't he just take the stand and come out here and just explain what was going through his mind? Can't even comment on that. If you do, now you're encroaching on his right to remain silent. Part of that right is to protect yourself, right? And to prevent people from making those types of statements in court. And the defense and the court wants to make sure the jurors are not going to hold that against them. Also very important. Some of the witnesses in this case may be people who testify under an order from the court giving them immunity. Are you going to hold that against anybody? Shouldn't be doing that either. This person, you might say, is involved or lacking in credibility. But if they're being given immunity, we've got to have you consider them on face value. Question 80, the judge will instruct you that the charge in this case includes making a false statement to a federal agency. Would this charge make your ability to be fair problematic? And there are some charges that just, if people hear charges, if they hear like a crime involving somebody of a certain category, they just say, I don't even need to hear the evidence. How old was that child? Oh, don't even need to hear the evidence. Yeah. Oh, it's done. Yeah. Right. And they say, he's in handcuffs. He's in a jumpsuit. That's all I need to see. Other people, right, for those types of crimes, those are certain crimes that are very sort of universally reviled, rightfully so. But there are other crimes like this one, which fall into a unique category of a lie. We call these crimes of moral turpitude. And if you're lying, making false statements, fraud, forgery, theft, burglary, any of those crimes, making a false statement, right? Those are kind of in a different category of crimes. There are some crimes when people are just, they make mistakes. They're have too much alcohol. They get disorderly. They are in an argument with their spouse. They, smash a breakfast bowl or something, and a neighbor calls the cops. It's a heat of passion type of an argument. It's a domestic violence charge, disorderly conduct. Some people are speeding, right? Criminal speeding or reckless driving. You're just kind of going too fast, not paying attention. Some people get DUIs. All of these things are crimes. They're conduct that society has said is not good. And we want to criminalize it because we want less of that, presumably is what they say. But there are other crimes that are just lies, right? These are people, unlike those crimes that can happen to kind of anybody, bad luck kind of a situation is one way to explain it. But there's another crime where people are actively, voluntarily, volitionally engaging in lies. They're actually saying, I'm going to go take that thing from you. I'm going to show up with a white paper that I know is fake, and I'm going to make a false statement. I'm going to lie to the FBI, telling them I'm not there on behalf of anybody else. Then I'm going to go back to my office and put a log in my billing ledger, billing the Hillary Clinton campaign for it. That's a different type of crime. That's a different type of mental state. That's somebody who is actively sort of scheming, right? They're engaging in this guilty mind type of thinking. And so we put that into in sort of a different category. Crimes of moral turpitude, there are different things that might have consequences for certain collateral consequences like immigration and stuff. In criminal law, you might get a sentencing enhancement for that, right? It's, hey, you knew what you were doing was wrong and you did it anyways. And you did it multiple times and you knew better. You should have known better, but you did it. Versus somebody else who's like, I just made a mistake, right? I was just a young person. I just screwed up. I got in over my head. Different categories. Here, they're specifically asking about that. This person made a false statement. Is that going to be a problem for you? Yes or no? They're also instructing the jurors that jurors are the sole judges of facts. However, the jury must follow the law that I give you as the judge. They may not follow some rules of law and ignore others. Even if the jury disagrees or dislikes the rule or does not understand the reasons for the rules, they got to follow them. Do you have any personal beliefs that would deviate you from that? Whatever they may be, if yes, let us know. And this is where you see some of those sort of, jury nullification arguments, people coming in and saying, well, I just don't believe in that law and I'm not going to enforce unjust laws. And so I'm going to make a stand here that lying to the FBI should not be a law, free speech or something, right? And I'm just going to take a stand on this case. The judge is going to say, no, you can't do that. There's a mechanism for that. If you don't like the laws, go vote out the Congress people who pass them. But this is where we apply the law. You get to decide the facts of the case, but you have to apply the law as instructed. Continue, says, if during the course of jury deliberations, a fellow juror should suggest that you disregard the law or nullify this thing, would you be able to, as a juror, reject that suggestion and abide by your oath? The judge will instruct you that an indictment is not evidence. The criminal document that is charging him says that document is just the charge. It's not evidence. Can you treat it as such? Yes or no? Is there anything about this case at all, or the people involved, that you could not be completely fair to Michael Sussmann in the U.S. government in this case? Yes or no? And that was sort of that question that I was telling you about in that one jury trial I did. Anything else that we should know Lady's like, I hate all police. Ugh. Okay, well, thanks for letting us know. We get to the concluding questions, then we'll check in with the chat before we wrap it up on this lovely Sunday. But here are the concluding questions. And remember, there are people right now, probably 100 of them, if not more than that, filling this out, right? Like literally right now in real time. They're sitting there back east in DC. It's like 8 o'clock. They've got to be at court tomorrow morning at 9 a.m. And they're like, this is never ending. Welcome, Wolfgang Deo. Just became a member. Shout out to Wolfgang. This thing just keeps going. Now we're on page 27, but we are wrapping it up. Concluding questions. If you were selected to serve on this jury, would you consider and respect the view of other jurors, even if their views differed from yours in accordance with our instructions? Yes or no? Do you have any personal reason for wanting to serve as a juror on this case? Yes or no? Are you a political aficionado? Are you somebody who wants to, make a political statement or a cause? Are you just very curious about this? Let us know. 87 says, if you're selected as a juror, would you be concerned about reactions to your verdict? Because a lot of people are going to be feeling a way about this when it's over. Sussmann's either going to be found guilty, and we'll see how far these tentacles go, or Sussmann is going to be acquitted, and that may be the end of the Durham investigation. It may not go any further than that. We'll have to see. But there's going to be a reaction one way or the other. Is there anything you prefer to discuss privately with the judge? If so, let us know. And is there anything else about the subject matter of this case or the points covered in the questionnaire which creates a question in your mind whether you can be fair? Yes or no? Jurors then go to page 28 of 32. By signing below, I declare under penalty of perjury that all of my answers are true. I have not discussed this with anybody else. I've answered all of them myself. Type your name right there. Sign off on that baby. Date it. Fill these additional pages out if you have any other questions or any other, if you need room. You say, I really hate Donald Trump because of whatever, collusion. Judge will read it. You have the attachment A. Now, they didn't give us the list of the witnesses. Remember, in attachment A, they were going to tell us what the witnesses were, but we don't have that. So that is the entirety. Now, that took us about, a good hour to get through, but I meandered from time to time on a couple different tangents, but it's a big questionnaire, 32 pages. And as many people acknowledge, quite invasive. Death asking, can you refuse to answer these questions? They seem invasive. Wolfgang Deo saying, if this guy was able to lie, why not lie here? So I think he's talking about Sussmann. Sussmann, of course, was somebody who is charged with lying. That's the allegation. But he's still presumed innocent until he's found guilty. And trial is going to start tomorrow, and we're going to be covering a lot of that. Let's see, I wanted to show briefly what else is happening with this other guy. So remember that tomorrow we've got jury selection starting. I have a plan to get transcripts sort of in real time. I think a morning session and an afternoon session should be coming in hot. Like as soon as they're done with those sessions, the court reporters are going to be finalizing those and sending them in basically real time as soon as they're finalized, of course. But we'll get those tomorrow. But there is probably going to be some more activity on the court docket. And I wanted to show you something that I mentioned at the beginning of this thing. So here is this guy. His name is Eric Lichtblau, and he is a New York Times columnist. He was an American journalist reporting for the New York Times, Washington Post. He earned 2 Pulitzer Prizes. In 2006, one wiretapping from the NSA. There was a controversy here about the 2016 election. And he published some story or whatever, right? So he's somebody who's highly involved in this. Now, he filed a motion for a protective order saying that he's about to be called in to testify, and he does not want this to be something that is allowed, essentially. So let's take a quick look at this. Now, we're not going to go through this. It's 13 pages, but I just want to show you the nuts and bolts. Let's see if I can actually pull this up on a bigger screen. I thought I had that pulled up. So let me download this real quickly here. And then I will open that up. So we don't know much about him yet. This is the first time I've actually heard of his name. Let's see here. We have this. Now, non-party Eric Lichtblau. So he's not actually involved in the trial, right? He was not named in the indictment. We did not see a motion to intervene coming out of him. He is a New York Times columnist, as I mentioned, and he's filing a protective order. So let's see what this says. He's an award-winning news reporter. He was the author of the article from October 31st, 2016, investigating Donald Trump. So he published that. He identified in the indictment as reporter number 1. He communicated with Sussmann in advance of the meeting with the FBI. So this is a New York Times reporter who's communicating back and forth with Sussmann while all of this is going on. And look, the article is October 31st. Remember, the election's a few days away in November. This was the October surprise. Hillary is going into the can. Donald Trump is rising unexpectedly, and they are freaking out. So they come up with this story. This newspaper, New York Times reporter, is communicating with Sussmann. Sussmann is the same guy who's taking it, of course, over to the FBI. Sussmann has waived confidentiality about his conversations with this reporter. So it sounds like Sussmann has subpoenaed him, right? Sussmann wants him to come and testify. He's saying, I'm not going to maintain confidentiality. Lichtblau, though, this columnist, has raised concerns about protecting privilege. And so he's trying to protect his sources. So he's saying if Sussmann calls him and he's the subject of questioning, they want the judge to limit what he can talk about. Saying that he's got privileges, right? He's a journalist, and there are protections for that. First Amendment protections to make sure that people are being allowed to protect their sources. And saying that if he is called to testify, maybe he can talk about some of the things that Sussmann says that they communicated about, but he wants this limited so that it can't go beyond that scope. We talk a lot about the hula hoop here, and he's trying to make sure that that thing is narrowly tailored. Also says, wants the same thing from Durham. Says special counsel Durham has refused similarly to limit the scope of his questioning, stated that he can't provide any assurance that cross-examination of Lichtblau would be confined to his communications with Sussmann. So Sussmann is going to call Lichtblau. Lichtblau wants Sussmann to not ask him questions. And Lichtblau also wants Durham to only be limited to what was brought up on direct exam, which the judge will probably limit to some degree. To the contrary, counsel for the government stated that certain of Lichtblau's email communications with third parties during the course of his news reporting were within the prosecution's possession and that they might be able to examine him about that. So we're going to get, this trial just keeps going and going and going. We're going to get potentially New York Times reporters called up onto the stand, asked about their fake 2016 collusion hoaxes. Now, I'm not going to go through the rest of this, but you can see this is sort of a non-party. This is somebody who is not ultra involved in this case, other than they may be, an ancillary witness about a story that was being written. But he's got a lawyer. He's lawyered up, and he wants the judge to grant this protective order because he doesn't want to talk. Yeah, it's qualified reporter's privilege applies here. So he's protected by all the First Amendment journalistic protections that are afforded by our Constitution. And so that's about it, my friends. Now we're taking a look at the docket. Let's do a quick refresh, make sure nothing's hitting late on Sunday night. We've got a notice. Here's a notice about. Oh, all right. Well, we might as well take a look at this since we're here. This is another big one. 5 pages. We can do this quickly. Let's just pull this up while we're here. So I'm going to save this. I'm going to pull it open in the right browser so that I can draw on it for us all here. But this is the opinion and the order. Okay, so remember that previously we talked about this. 5 pages, we can go through this relatively quickly, but both sides are sort of objecting to their exhibits. And we talked a lot about this last week, but Durham and the defense submitted their exhibits list. And in it, they had all these news articles. And what they were trying to do is make Sussmann look like somebody who was acting very reasonably. Back then in 2016, everybody was talking about Donald Trump and Russian collusion. Sussmann was reading all of the articles, and he was coming to the logical conclusion that Trump was colluding with Russia based on all of these articles. So the defense wants to submit those articles to provide context for what Sussmann was doing. If there's no context, Sussmann is going to look like this maniac who just got these white papers and just brought them down to the FBI and just said, I just found these white papers on the internet or something, and I think there's something here, which is basically what happened, right? This all was concocted by Perkins Coie, Fusion GPS, Rodney Jaffe, and all of these people. So that's essentially what happened, is he just got these documents and dragged them over there. But what the defense is trying to do is say, no, that's not true. He stumbled upon this information because there was so much of it out there. Everybody was talking about Trump-Russia collusion, and Sussmann was just sort of, oh, he came across it and just, oh, I better go take this to the FBI because I'm such a good Samaritan. And they wanted to submit like a few dozen articles to support that claim. And we were saying, oh, well, this is what they have this ugly, thing that they got to deal with. So they're going to wrap it all around in all of these tangential articles that really are sort of relevant, but not really. And they're going to try to make it look like Sussmann was doing what everybody else was doing. Rather than making him that one thing that just doesn't belong there, he does the same thing as everybody else. Now, the prosecution objected to all of those exhibits. They said, you don't need all those stories. That's not relevant to anything. He came in, he lied to the FBI. He said he wasn't there for Hillary. He was there for Hillary. That's it. End of story. We don't need the context about what the New York Times was saying, what Washington Post and all of these other media entities were all complaining about back then. Prosecution objected. Now the judge is giving us an opinion. Says, all right, everybody, trial is starting on Monday. Literally, I'm tired of you two fighting. Says the parties have each lodged various objections to each other side's exhibits list. Court addressed some of this stuff previously, but the court now is going to address a particular set of exhibits the defense seeks to offer. Oh, this is not even those. This is different. These are the two handwritten notes taken by the DOJ. Wow, this is good. I'm glad I opened this one. Now, those meetings, DOJ handwritten notes taken by the DOJ at the March 6, 2017 meeting. Okay, so those are actually a different set of notes. Those are not the notes that the FBI took. Okay, we have talked about those two sets of notes that came over from here. We saw Trish Anderson's notes. Trish Anderson wrote this set of notes that said no specific client, but a group of cyber academics. But this is not from that. This is from September 19, 2016. These were Trish's notes on Sussmann's meeting with Baker. Sussmann met with Baker in September. Baker told Trisha. Trisha took notes about that conversation. Same thing that Bill did. But there was another set of notes that took place in March after Trump won. And I made a video about this. The FBI panicked after the Trump tweet. Let me pull these slides open because I have these slides right here. And this was also fun. So if we recall, there were these notes. You see this right here. There were these notes that came out of that meeting. These were attachments previously. So Saturday tweet. This is when the FBI was very paranoid about Donald Trump posting that tweet that looked like this one. Remember, Trump posted this tweet. He said, terrible. Just found out that Obama had my wires tapped in Trump Tower just before the victory. Nothing found. This is McCarthyism. Well, that was on March 4th. And a couple days after that, on March, I think 7th is what it was, everybody's meeting in the DOJ room and they're all freaking out about this. We have several different exhibits here. Exhibit A, Saturday tweet. What is behind it? There's an article from Friday and they're all freaking out about that. Here's another person taking notes. FBI on 3/6. FBI is trying to determine what is behind POTUS tweets. Possibly a computer server at Alpha Bank. Another FBI aide or another DOJ person freaking out. Tweet activity. All the people, or I think that might be AM, which is Andy McCabe, trying to figure out what this is all about. Breitbart articles coming out and they're all responding to Donald Trump, all concerned about it. So we know that they want Durham and the prosecutors want to get that stuff admitted in as evidence. We're going to close out of the questionnaire. Let's leave that one. We have that opinion in order. Let's pull this one here. So this is the order now about those notes, about these notes from the DOJ meeting. We have those. Let's go back to the order. As it did in its order on the parties, the motions in limine addressing the notes, the court will lay out the steps needed to admit the notes. Okay. So essentially it sounds like the judge is going to say this stuff can come in. Parties, exhibits, saying the defense is going to seek to introduce those notes that we just showed. The notes suggest the meeting was a briefing for then Acting Attorney General Dana Boente at the FBI various ongoing issues. Many people were there. James Baker was there, Tricia Anderson, Will Price-Stepp. The notes taken by Ms. McCord, Ms. Gower suggest that Mr. McCabe advised the group that the Alpha Bank allegations were shared by the FBI by an attorney on behalf of his client, or by an attorney who did not say who the client was. Analysis. So this is a double hearsay problem, 2 levels. Mr. McCabe's statement at the meeting. The second, the note taker's memorialization of the statement in writing. So if you've been following, I think the Johnny Depp trial, I have not really, but I know a lot of people have. But I know that one of the ongoing themes from all of the memes has been hearsay, right? Hearsay, 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 because they're asking questions about what people said outside of court. And it's all being offered for the truth of the matter asserted. Here, same type of issue. The defense now in this case, trying to bring in Mr. McCabe's statement. And this is also important. They're trying to bring in these statements because here, there were some notes in one of these messages here, right here at the bottom. Attorney brought to FBI on behalf of his client. You can see it sort of right here. I'm circling my mouse around it. But attorney brought to the FBI on behalf of the client. Now, that is what Andy McCabe actually said at the meeting. And so he said something, which is hearsay. She wrote it down, which is also hearsay. And so it's saying the defense must proffer either a non-hearsay rationale or an exception at each level of the hearsay. So you got to go through each one of those. How do you get the notes in? How do you get Andy McCabe's statement in? Or you just have to come up with a whole nother rationale. The judge is giving the defense instructions, literally. Did the same thing for the prosecution previously on the notes for Trish and Bill. But this is fun. It says, starting with McCabe's statement, the defense submits it does not intend to offer it for the truth of the matter asserted, therefore saying it's not hearsay. Instead, the defense intends to offer the statement as evidence of the state of mind of the attendees at the meeting, which would be an exception, most notably Mr. Baker, as well as the FBI. The defense also wants to use the statement to impeach Mr. Baker by pointing out that if Mr. Baker had disagreed with Mr. McCabe at this point, if Mr. Sussmann had actually told him he was not at the meeting on behalf of a client, Baker presumably would have made it known. You see where this is going? You can just see where this is going. This is, you can see. All right, so Mr. Baker is going to be a pretty important witness. We don't know how he's going to testify, but you can see where this is going. All right, so let's break this down a little bit. If we go back over to the mind map, remember, the original September 2016 meeting was between James and Sussmann. That's it. These two people were communicating via text message. They had multiple conversations before the meeting ever took place. They were essentially buddies. Jim Baker, somebody I believe is now working over at Twitter, you can probably guess what his political leanings are. They have a meeting. Jim Baker, the thing that he did that is really hurting Sussmann right now is he communicated that Sussmann said he was not there on behalf of another client. Trish Anderson memorialized those notes. Deputy Director Bill Price-Stepp also memorialized those notes. Now, that's fatal to Sussmann's case. He's saying, I was not there on behalf of another client. You got 3 people who presumably in September all said, yeah, you were. Or I'll say, yeah, you did. You did say that you were not here on behalf of a client, but you were. So if they all have that, right? They have to start whittling away at this. They've got to take them off one at a time. So then what they're going to say, this is what the defense is arguing. He's going to say, let's fast forward the clock. This all took place in September. We fast forward to March. When we get to March, we have another meeting now. Remember, Donald Trump is elected president. So changing of the guard starts. There's a meeting with the new acting attorney general. It's taking place wherever it's taking. James Baker is there. They all know, they're all panicked now because they all know that Trump knows about this because of his tweet that he posted on that Saturday that they're all freaking out about in this conversation. So Andy McCabe then goes back out, and this is in March. And we all know Andy McCabe too. Okay, he's somebody who's been very involved in all this. He's not on the mind map, but he's going to be. He, at this meeting, volunteers outwardly, right? He says, oh, yeah, they were there on behalf of another client. So he's fixing the problem. Okay, Baker screwed Sussmann, and McCabe's part of this entire conspiracy also. And so they're repairing it. They fast forward. It's now March. They know Trump knows about the spying because he just tweeted about it. So then McCabe at the meeting comes out, FBI says, we know that Sussmann brought somebody information on behalf of his client. So he papers over it. He puts a Band-Aid over the whole thing at the meeting. And now the defense is noting, saying that Baker was also at that same meeting and he didn't object to this. So when Andy McCabe at the meeting said something like, yeah, Sussmann, the attorney, brought the information to the FBI on behalf of another client, Jim Baker did not correct that. Why might that be? Because Jim Baker, that's the reality, right? Jim Baker now is somebody who incorrectly remembered things the first time, but he got it correct the second time. Or he just got caught with his hand in the cookie jar, right? Now all these guys are at this meeting. Trump's tweeting about this thing. Hey, I know what you guys did. Andy McCabe's like, well, I got to tell you about what's going on with this Trump-Russia collusion thing. Yeah. Back in September, before the election, this lawyer named Michael Sussmann, he went over to the FBI and he told them he was there on behalf of the Clintons, and they had a conversation with him. And this is in 2017. So Sussmann hasn't been charged yet. They're papering over the whole thing. Insane. But that's how this defense is going to go. They're just going to try to layer on top of that. All right, so we go back to this. They continue. They say, if offered for the purpose that the defense describes, McCabe's statement would not be evidence of truth of the matter asserted. Accordingly, McCabe's statement is not hearsay, and the defense would be permitted to introduce it at trial subject to the appropriate limiting instruction, and provided it has a percipient witness who could testify to the statement. However, McCabe is not on either party's witness list, and apparently neither of the note takers who are expected to testify clearly remember him making the statement in the meeting. So the people who actually wrote the notes, maybe McCabe's not going to be here at all. Interesting. So the judge says that brings the court to the second level of hearsay, whether the statement can be admitted through the notes, which are themselves out of court statements. So talking specifically about these notes, can we get those statements in? Says, the defense anticipates that the note taker's testimony will lay the foundation for admission of the notes as past recorded recollections. Namely, the defense expects the note takers, the people who took those notes, will not be able to independently recall what was said at the meeting. Yeah, because it was 5 years ago. As with the notes, special counsel wishes to admit if the witness's testimony lays the foundation, they may be read into evidence, but that's it. The defense also argues testimony will lay the foundation for admitting the notes themselves. There is precedent, a lot of legal stuff here. Having established these general parameters, the court will reserve judgment on whether a foundation has been laid for the admission of the notes until the trial. All right. So they can mention them in its opening statement. So really no ruling on that one, other than the judge, Christopher Cooper, laying out some general, guidelines on that. But we'll see what happens. Mr. McCabe, of course, the subject of a lot of the conversation in that opinion, but he's not even on their witness lists. But I think the defense really does want to get that in, because that would be very useful. If they can show, if the jurors could just see two competing notes, that's reasonable doubt in my perspective, right? You start to smash those two things together and you make that argument. Well, they said this and then they said this. If you're a juror, you wouldn't buy it. What's the counter to that? Well, the March meeting, everybody at that meeting had a lot of basis for wanting to cover their butts. So of course they all said, no, clearly he said he was there on behalf of a client. Didn't you, Michael Sussmann? Michael said, no, I was. Oh, yes. Oh, I forgot. Yes, I did mention I was there on behalf of Hillary. Now that you mention it. Oh my goodness. Okay. So this is going to be a lot of fun. Let's see. There's nothing else that I think is worth covering on the docket. We have another response. So all the Eric Lichtblau stuff. All right. Well, I think that's about it, my friends. I saw another super chat come in here from Sean Brem. Says, evidence tampering by that whole group to produce red herrings to distract the Trump administration. Yeah, I think there's a lot of truth. Look, Donald Trump had to deal with this his entire first administration, the entire 4 years, essentially, right? Everything was Russia collusion, nonstop. He even got impeached over the whole thing. We talked about a lot of it here. Ambassador Vasilyuk and the whole thing. I think it really did a number on how he was able to be effective. And then it honestly, it carried into 2020. And it still sort of tainted him. And when I tell people about this, and this trial taking place, they just go, that whole thing was fake? What? They still don't get it, right? It's still been seared into their brains. And it's a scary thing what the media can do. And what's even scarier is you're only seeing repercussions just now in the years 2022. So what happens? I mean, you can see what are the consequences? By the time the law catches up with you, you may have already won the presidency. That's a pretty powerful thing. So it may be worth the gamble, which is why we have to continue to be vigilant about what happens in our elections, as I think everybody can understand. All right. And so I want to see what is happening over on locals. See, oh, Vientikis is in the house. Shout out to Vientikis. Vientikis has potatoes that are growing. Let me share this with you. Let me show you Vientikis's potatoes. Hopefully you don't mind, V, but these are beautiful. So these are Vientikis's potatoes growing in a potato sack. Is that a potato sack? I guess it looks like a potato sack. That's from Vientikis over on locals. Let's see what else we have over there. Sugar Britches is in the house. Tweak is here. They're talking about Sweden with Vientikis. Three Girlies is here. Shout out to Three Girlies and the other girlies over there. Ed Johnson. JC the Music Man's over there. And so those are some shout outs from our locals community. We've got K-Bean. Thank you, K-Bean, for the mods. We've got Just Cause is in the house. I saw Zulu earlier. Lean is here. Hello, Lean. It's been a long time since I've seen you. Welcome. We have Scott McClish, Playing Hooky, Paul, me no, and Texas Beast are all chatting away. And so I appreciate everybody joining us for the program today. We are going to be back tomorrow. Now, until we get our bearings straight and figure out exactly what we're doing with the transcripts and the live streams and all of that, I'm not sure when I'm going to get all this stuff in. So I'm sort of, the way I was thinking about it in my mind is we'll get a morning transcript, we'll do a stream, we'll go through those transcripts. And I don't, I've never read an entire trial before on, out loud ever. And I'm not sure that makes for really good video content, but we'll go through it. We'll see what stands out. If it's a lot of the same stuff, we'll skip over that and try to dig into some of the juicy bits. But I think that we'll get a morning transcript and an evening transcript, but I just don't know when they will be. And of course, I am 3 hours behind the DC Circuit Court. So we'll get, if it's, let's say if I get the morning docket around, 1 or 2 in the afternoon after the lunch hour, then that will be like 10, 11 here. And same thing, close of business. Yeah, so we'll see. And we might be able to time it, whereas we just do the morning trial, and by the time we're done with morning, we get the afternoon trial, and we just bang through the whole stream in a matter of, 3 hours. But we've got a lot to get to, and it's going to be a lot of fun. And I appreciate you being here and your support of the channel, of the show. I love it when you leave those likes. It really helps the YouTube algorithm, and it helps the channel grow when you share it and subscribe. And so I appreciate your support there as well. But that, my friends, is it for us for the day. We're going to be back here tomorrow. I'm not sure what time yet, but it will be a live stream. And we're going to go see what's happening in Michael Sussmann's case. Jury selection will be underway. Federal court, jury selection happens pretty quickly. Right? Oftentimes, we can get a whole jury impaneled within a matter of days. I mean, it's very, very quick. And then we'll jump into opening arguments. We'll see what the transcripts look like. There is not going to be a phone call-in line. So either journalists are going to have to be there at the actual courthouse, or they're going to have to read the transcripts like what we're doing. And so we're going to get the transcripts like immediately as they come in. It is, somewhat of an expense. And so that's where your super chats and support is all going. And I very much appreciate that, but it's going to be a lot of fun. And I think it's going to be well worth our time. And so I appreciate you joining us on that. Everybody have a tremendous rest of your Sunday night. Hope everybody brings the weekend to a nice close, is really nice and relaxed, got those energy banks recharged and ready to get into a whole brand new week ahead covering Sussmann. I look forward to seeing you back here. Have a tremendous weekend, a tremendous night. See you on the next one, my friends. Bye-bye.